I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Texas versus United States. This is a Fifth Circuit Court of Appeals case or decision from 2015 about DAPA and DACA, those immigration programs from the Obama years. And we're studying this case to look at the distinction the court makes between legislative rules or regulations and what the agency calls policy statements. Let me preview the issue here for my students and put this in context. The Administrative Procedure Act sets forth rules that agencies have to follow, regulatory agencies, when they promulgate regulations. And they can either do it with full-blown formal trial-like proceedings or with something called a notice and public comment period, which the APA calls for purposes is informal rulemaking. And Section 553 of the APA sets forth these procedures that the agency is supposed to publish a proposed rule in the Federal Register, allow a public comment period, then publish a final rule where they respond to some of the comments that they've received. There's an exception, and the exception is really what this case is all about. For a few things that agencies might need to do, internal organizational documents, and also general statements of policy or interpretive rules. And so those are exempt from the APA's procedural requirements. And in turn, probably don't permit, are not available for judicial review. In other words, the courts don't really have jurisdiction to review something that's just an announcement of, let's say, our sort of classic case or archetype would be just a general announcement about enforcement priorities or how long they're going to take to do something or something like that. That's not really a rule, it's a policy, an announcement. And so those aren't usually reviewable by courts, and the agency doesn't have to go through notice and comment rulemaking. The problem is that sometimes it's kind of hard, sometimes the policy statements look a lot like a rule or have the practical effect of being a rule or a regulation. And then the parties can argue this really should have gone through notice and comment rulemaking. Or the agency may be arguing, it looks like a rule, but there's no judicial review here. And that's what's really going on legally in this case, beneath the sort of very controversial public policy issues with immigration. And so let's look at what happens in Texas v. United States. We start in 2012 during the Obama's second term. The Department of Homeland Security implemented something called the Deferred Action for Childhood Arrivals Program, or DACA. You may have also heard this in the news media associated with Dreamers. So the idea is that there's some undocumented immigrants who arrived here as babies or young children. They didn't make a decision or have any control about whether they crossed a border or anything like that. And in some cases, they've lived here their whole lives. This is really their home and the only experience they've ever known. And so DACA is really for these immigrants who arrive as children. And it basically would give deferred action. In other words, would sort of allow them to indefinitely avoid deportation proceedings as long as they met certain specified criteria in the memo, the DACA memo that was put out. Okay, so let's keep going. DHS followed up in 2014 with another program or memo called Deferred Action for Parents of Americans and Lawful Permanent Residents. And so this is DAPA. So if I'm going to oversimplify here for those who might be unfamiliar with these technical terms in immigration, DACA was the program for kids or children, and DAPA is for parents. And so parents of undocumented parents, if the parents are undocumented immigrants, but they have kids that are citizens. Maybe the child was actually born here on American soil, or legal permanent residents. So maybe the child is old enough that they won the green card lottery or something like that, that the parents can then also avoid deportation and have some other procedural rights and protections as long as they met certain criteria. So Texas and a group of other states sued the federal government, basically arguing that the DAPA program should have gone through APA notice and comment rulemaking procedures. And they had some other claims too about that it violated the statutory scheme and was unconstitutional generally and so forth. Our interest here, the reason we're reading the case, is just about whether this was supposed to go through notice and comment rulemaking, and also if it doesn't, because it's a policy statement, that says something about whether judicial review is available, which is also a critical issue in this case. Now, the district court sided with Texas and the other plaintiffs on this particular point and granted a preliminary injunction. And the district court's opinion, first of all, it has to work through several issues, a very, very long discussion about whether these states have standing to challenge this. And then this question of whether this is just a policy statement, as the agency was saying, which would preclude make it kind of premature for judicial review, and also meant they didn't have to do notice and comment rulemaking, or is it functionally a regulation? And then the court doesn't really have to resolve the other issues, although it addresses them some. And then we go to the Fifth Circuit, and that's the opinion in your casebook. The Fifth Circuit Court of Appeals affirmed the Texas District Court, Judge Hanen's opinion, saying that DAPA did not qualify as a public statement under the APA. And this meant that DHS should have gone through notice and comment rulemaking procedures, and that judicial review should be available. Now, DHS had claimed that the DAPA memo was merely a policy statement, and therefore they could avail themselves of this exception to the Administrative Procedure Act's requirements. And so that would make it exempt from notice and comment rules, and also, for the time being, exempt from judicial scrutiny. The court here, the Fifth Circuit, borrowed some language, or relied heavily on a sister circuit, the DC Circuit Court of Appeals, and a case, General Electric versus EPA. That case, by the way, is also in the casebook that I use for my course. To distinguish policy statements from legislative rules. Remember, on its face, it's not always clear which this is. And usually the agency, almost always the agency is going to be saying this is a policy statement. And the party that's challenging it is saying, no, this is actually really a rule or a regulation. So number one, the first prong is whether the rule creates rights or legal duties. And number two, whether the rule, quote, genuinely leaves the agency and its decision makers free to exercise discretion. Both of these are really going to the question of, is this binding or non-binding? And at least in practice. And so if it's binding, then it's a legislative rule, and we should go through notice and comment rulemaking, and it will count as a final agency action that can trigger, makes judicial review available. And if it's non-binding, then it might just be kind of a general announcement of the agency's policy. And so a few highlights from the case here. The court has to admit that the DAPA memo facially purports to confer discretion by allowing case-by-case review and use of discretion in decisions. In other words, what DHS did is they put language right in the text of the document creating the DAPA program saying this is non-binding, and which the court here thinks was really just a pretext and a way to preempt judicial scrutiny or judicial intervention, and to preempt any need to do notice and comment rulemaking. And the district court had found that, and the Fifth Circuit agrees. The district court found that these statements of, hey, this is just a policy statement and it's non-binding, was merely a pretext, because the staff that were actually implementing the program thought that they had basically been ordered to grant deferred action to these parents. And then there's a confusing part of the case, if you're not reading it carefully, where both for the district court and the Fifth Circuit opinions, then to have this long discussion about the other memo that's not even being challenged in this case, and that's the DACA memo, which is about kids. And basically, the discussion was that the DACA memo had tried to do the same thing, that it also included this language about how it was just a policy statement and non-binding, but in practice, there was evidence that the staff had been approving 95% of the obligations, which made that memo language about being non-binding seem like a pretext. And basically, the government employees who had been processing DACA applications, the first memo, said that they had received oral instructions in the office. The word was around the office that they were basically supposed to grant the applications, and there were very, very few denials. So in practice, the document said one thing, but the agency staff are being told in the office, you should be granting these. That's our goal. And so the circuit court accepted that finding from the district court, and the implication that DAPA was basically going to operate the same way. And it said memos, both of these memos purport to grant discretion. They say that they're discretionary and non-binding, but a rule can be binding if it's applied by the agency in a way that indicates it's binding. And remember, if it's binding, then it counts as a legislative rule, so notice and comment is required and judicial review would be available. We do have a dissenting opinion, and remember that circuit courts are 3-judge panels, so this is 2-1, and the one judge who didn't agree said that the DAPA memo really was just a policy statement. It did not, and therefore qualifies for the exemption, and notice and comment procedures are not required. And it also has a long discussion, the dissenting opinion, about who has the burden here. And it basically says the plaintiffs, like Texas, have the burden of showing that that this memo is binding on the agency or non-discretionary. And they say, the dissent says, that's a pretty high burden considering the wording and substance of the memorandum on its face sounds discretionary. The plain meaning of the words is, it says this is non-binding and discretionary. And so that's a pretty high burden. And they think that there's a lot of reasons to take what the agency puts in writing at face value. Okay, where does this leave us? Well, sometimes to avoid undergoing notice and comment procedures, which can take a long time and a lot of hassle, agencies might characterize one of their policy documents as really just a policy statement or announcement rather than a rule or regulation. And this may occur after the fact. We read some cases like the Overton Park decision where the agency made a decision about a highway, and then when it was challenged in court, then they started to kind of drum up reasons for doing it and reasons that they didn't have to do it and so forth. And the same, we have some other cases like that. Or the agency might try to characterize what they're doing this way up front, like here, where the agency just inserts verbiage to make a policy sound discretionary and non-binding, sort of trying to forestall or preempt this very type of situation where we have judicial review and questions about why didn't you follow the APA. And also your big takeaway, if you don't get anything else from this case, it's that some of our big circuits like the Fifth Circuit and the DC Circuit are saying that just because an agency document says it is merely a policy statement does not make it so. The statement matters. I'm not saying they don't say that what the document says is irrelevant. They actually take it say that we have to take this very seriously. It says it's non-binding on its face, but The courts can also look at what the agency does in practice, and that really can matter and can outweigh what the document says. Whether a text is determined to be a policy statement or a regulation or rule, remember, affects whether rulemaking procedures apply and whether judicial review will be available. A final note about what happened in the aftermath with this case. The federal government appealed their loss here at the Fifth Circuit to the US Supreme Court, and the Supreme Court granted cert. But between granting certiorari and having oral arguments, Justice Scalia passed away. So the court had an even split of 8 justices who were divided on party lines about these immigration policies. So the court affirmed the Fifth Circuit by a tied vote 4-4, but didn't publish an opinion. So they didn't say why they were doing what they were doing, and that means that they left unclear which holdings were affirmed by this. Remember, there were several holdings in this case. A lot of the opinion that's probably you're not expected to read from my class is about standing. And then there were some other issues addressed. And so it's unclear whether this sort of tacit or opinionless affirmance is about the standing question and some other things in the policy overall, the legality of the policy, or what it really says about if it is agreeing with the Fifth Circuit's sort of standard or rule about policy statements. Okay, that concludes our lecture about Texas versus United States.